Today I'm going to speak to you a little bit about my office. I'm the Advocate for Business, and give you an idea of what we do. So there are two advocates at the board. One is the Advocate for Injured Workers, Joe Cavalcante. He handles the injured worker community, and I'm the Advocate for Business, and I work with employers across the state. My office is there to assist businesses with all kinds of questions they might have related to coverage and compliance. I travel in non-COVID days across the state and do presentations for businesses, business owners, organizations, chambers of commerces, government groups, and talk to them about, about workers' comp, like what it is, who needs it, how do you get it, who doesn't need it, and listen also to things that are told to me by employers where the board might make improvements based on what I'm hearing out in the field. And I report directly to the chairman of the board so that those things that I learn on the road can be brought directly to the chair. So let's get down to it. What is workers' compensation insurance? Workers' comp insurance is a mandated insurance in the state of New York that covers on-the-job accidents, injuries, and illnesses, and it provides medical and wage replacement to injured workers. It also protects the employer from getting sued for that injury. Disability benefits cover off-the-job accidents, injuries, and illnesses, but does not provide medical care. It only provides limited wage replacement, no medical benefits, and that is up to $170 a week for a maximum of 26 weeks. That's disability benefits insurance. So who needs coverage and who doesn't? Businesses with employees need coverage. Sounds simple, but who's an employee? Basically, anybody providing any service to a for-profit business can be determined to be an employee of that business, and any compensated individual to a not-for-profit, with the exception of clergy and teachers, will be considered an employee and coverage would be required. So then who doesn't need it? Well, a sole proprietor, me working for me and nobody else. I don't need it. Partners, in a legal partnership, if only the partners are compensated with no employees, you don't need workers' compensation insurance. A one or two person corporation, a mom and pop, a husband and wife, they form a two-person corporation. They each hold at least one share of stock and own all the shares together, and they hold all the offices of that corporation. Coverage is not required. Once there's a third shareholder, even if he's not or she's not compensated, coverage is required. LLCs, if only the members of the LLC are compensated and nobody else, coverage is not required. So we know what coverage is, who needs it. What does it cost? How do you figure out how much it costs? Well, the cost for workers' comp insurance is called a premium, and there are classification codes that are created for every type of work that's done. For example, there's class codes for secretaries, class codes for construction, class codes for airline pilots, class codes for everything. And there's a cost applied to that classification code. For example, a class code for a secretary, clerical worker, might be 30 cents per $100 of payroll, as opposed to somebody that's doing construction, which could be $25 per $100 of payroll. It's per $100 of your payroll. And so obviously the size of your payroll matters, and also how safely you operate your business compared to other like businesses. If the average injury for your business is 25 a year and you have 10, your cost would be less. And conversely, if you have more accidents than is common or average in your industry, you'll be paying more. Also, every insurance carrier has administrative expenses, how they run their business. So it's always best to shop around, check the different prices that you're going to be paying at different carriers. Some specific coverage issues that come up, we've spoken about sole proprietors, partnerships. Family members need coverage. Domestic employees, if you're going to hire somebody to, say, be a nanny, take care of your children, if they work for you less than 40 hours a week, coverage is not required. If they work for you more than 40 hours a week, coverage is required. If they live with you and work less than 40 hours a week, coverage is required. And if they go on vacation with you and work less than 40 hours a week, coverage is required. So it's somewhat complicated. You can always reach out to my office at wcb.ny.gov and ask the question. If you're not sure, ask the question. Independent contractors and subcontractors is a very, very important area. Many people choose to think of their employees as independent contractors when in fact they are not. Everybody wants to be an independent contractor. The employee wants to be an independent contractor because he gets a bigger paycheck or she gets a bigger paycheck. And the employer wants you to be an independent contractor so they don't have to carry the proper insurances that you would for an employee. And that is all fine and good until somebody gets injured and they go to the hospital and the hospital says, did this happen at work? And the injured party says yes, and point to you as the employer who thought you now had an independent contractor who's now saying they want to be your employee. That will go before an administrative law judge in a claim, and 9 out of 10 times that law judge is going to rule that that independent contractor was your employee. We have 12 criteria that are used by our law judges to determine independent contractor status. They're on our website, wcb.ny.gov, and you must meet all 12 in order to be considered an independent contractor. The first couple are pretty easy. You know, who sets the control, the time that somebody comes to you? Does the person have their own FEIN? Do they have a separate business? Are they truly a separate business? Don't fool yourself, because this type of problem comes back to haunt employers more than I can tell you. So please go to our website, check the criteria. If you have a question, contact us and ask. As it relates to construction, there's the Construction Industry Fair Play Act, which the Department of Labor oversees, where workers are presumed to be an employee unless they can truly prove they have their own business. Go to labor.ny.gov, look up the Construction Industry Fair Play Act, and be very careful with that. General contractors under the law are liable for the uninsured claim of any subcontractor, which means that if you're the general contractor and you're going to hire somebody, you should become a certificate holder on their policy, because like automobile insurance, you can get workers' compensation insurance by putting a down payment, getting a policy, and then making monthly payments. So if somebody is a bad actor, they can get the coverage, never make another payment, give you the certificate of insurance, you think that they are covered when in fact they are not. And then at the end of the year, when you get audited by your carrier, you're going to get charged considerable premium because they were not insured and you were responsible for that uninsured subcontractor. If you are a certificate holder, you would be notified of that cancellation of policy. There are very significant penalties for not having the proper insurance that you were supposed to have, up to $2,000 for every 10 days that you're out of compliance, or $72,000 a year. If you have up to 5 employees, that's a misdemeanor. And if you have more than 5 employees, it's a Class C felony. Remember, before I talked about the premium, the classification code, some unscrupulous employers that need to get coverage to get a permit or a contract with someone will go to a carrier and lie to the carrier and get coverage. They'll tell the carrier everybody's a secretary, so they get a very inexpensive premium for the year. But in fact, those people are doing construction work. That's misclassification, and we treat that as an egregious penalty, as not having coverage at all, and those people are prosecuted to the full extent of the law. There is also something called the debarment law in New York State, which if you have any penalty with the Workers' Compensation Board, you are barred from getting a contract from the state or any municipality in the state for 1 year. And I bring this up because very often employers will have a disagreement with their insurance carrier over an audit. And rather than pay the amount the carrier is asking, they'll dispute it. They'll get into a war of words. The policy will cancel. They will end up winning the fight with the carrier, but now they've canceled, and now they have a penalty with us. And now, although they have their coverage back, they will be barred from getting any contract with any state entity or municipal entity for a year. There's no way out of it. So my strong suggestion is that if you find yourself in a disagreement with your carrier, you pay the price. You pay it. If you're correct, you'll get your money back. If you're incorrect, you should have paid it. Either way, you will not lapse with the board and you will not be placed on the debarment list. If you do have a penalty for us, realize the goal of the board is compliance. It is not to collect money on your penalty. So don't stick your head in the sand. It's not going to go away. We're like the gift that keeps on giving. We'll be there. So what you need to do is contact the board, and we will reduce the penalty based on your premium that you should have paid for the period of lapse. For example, if you had a $72,000 penalty and for not having insurance for your nanny, the annual premium for a nanny is about $500 a year. You were out a year, we would penalize you the maximum $2,000 instead of $72,000. But you need to have the proper insurance. If you have a penalty, make sure you have the proper insurance in place, contact the board, and that penalty will be reduced. There are ways to control the cost of your premium, and the first one is to make sure that you're paying the right amount of money. Make sure that you're in the proper class code. If you believe that you are not in the proper class code, you can appeal that to your carrier. They can deny your appeal. If that occurs and you still feel you're correct, you can appeal it to the Compensation Insurance Rating Board. The acronym is CIRB. They have thou shalt control. They will tell the carrier what's correct. So you can always do that. Also, follow your claims. If you have a claim, stay informed. Don't forget about it. Make sure your insurance carrier is doing everything they can to quickly settle that claim. And most importantly is operate safely. Set up a labor management safety committee. Take people from labor and management, change the chair monthly, schedule that meeting monthly, and have an agenda. Visit the workplace, review the equipment, the sites, the procedures. Remember, most accidents take place when employees take shortcuts. Who knows shortcuts better than the people doing it every day? Management doesn't know shortcuts. So you talk to the people that are doing it. Make sure that they're following the procedural guidelines that the equipment comes with. Make sure your procedures are safe and always train for safety. There is something called Code Rule 60, Workplace Safety Prevention Incentive Program. It's overseen by the Department of Labor, and there, if you set up a safety or a return to work or a drug and alcohol prevention program, you can save up to 10% of your premium in the first year and 6% thereafter. For more information on that, go to the Department of Labor website as listed here and look up Code Rule 60. Also, the New York State Department of Labor will come and visit your workplace and help you mitigate safety risks at no cost. Contact the Department of Labor. They'll come in and they'll look through your workplace and help you mitigate those safety risks, again, at no cost. So your responsibility as an employer is to make sure you have the proper workers' compensation, disability, and paid family leave insurance. You're going to get a poster that shows you have it. Put it up in a proper spot. If you have claims, report them timely. Section 120 of the Workers' Comp Law states that an employee cannot be discriminated against for filing a claim. You cannot fire somebody because they filed a workers' comp claim for an injury. Employees can only be terminated for valid business reasons. And employees are eligible regardless of their citizenship and or immigration status. If a worker notifies you that they've tested positive for COVID-19, you must report it to your carrier, who will file a claim with the board. In 2018, Governor Cuomo instituted and put into law New York State Paid Family Leave, which provides job-protected paid time off to bond with a child, care for a sick family member, or assist a family member when a service member is being deployed overseas. Virtually all private employers are required to provide paid family leave coverage. The employer must get the insurance and can deduct the cost from the employee's paychecks. The employees will pay the cost of the insurance. Sole proprietors and other self-employed individuals can voluntarily opt in for coverage. If they opt in within the first 26 weeks of starting a business, there's no waiting period. If they opt in after 26 weeks of starting a business, there's a 2-year waiting period. So again, who pays for that coverage? It's fully paid for by employee payroll contributions, unless you want to pay for it. The Department of Financial Services sets employee contribution rates to match the cost of coverage, and that information and a deduction calculator is available at paidfamilyleave.ny.gov/cost. So the key employer responsibilities, again, you need as an employer to get the coverage, provide the information to your employees about the coverage, provide the wage information to the carrier when an employee requests paid family leave, and you can always go on the employer section of paidfamilyleave.ny.gov for full details. COVID-19 quarantine leave. This is something new, and it provides workers with job protection and financial compensation when they or their minor dependent child are subject to a mandatory or precautionary order of quarantine or isolation. Most employees will get financial compensation by using a combination of benefits, which may include the new employer-provided paid sick leave, depending upon the size of the employer, paid family leave, and disability benefits. Your role in implementing the new COVID quarantine leave, whether you're self-insured or providing these benefits through an insurance carrier, is basically the same as it has been for New York paid family leave overall. There are new forms for COVID-19 quarantine leave available at paidfamilyleave.ny.gov/forms. And again, visit paidfamilyleave.ny.gov COVID-19 for full details, including the guidance for employers. COVID-19 quarantine leave, employers with 10 or fewer employees and a net income less than $1 million will provide job protection. Eligible employees may use paid family leave and disability benefits for the period of quarantine. Employers with 11 to 99 employees and employers with 10 or fewer employees and a net income greater than $1 million will provide at least 5 days of paid sick leave, provide job protection, and eligible employees may use paid family leave and disability benefits for the period of quarantine. Employers with 100 or more employees, as well as all public employers, will provide at least 14 days of paid sick leave and guaranteed job protection for that period of quarantine. For more information on paid family leave, here's the helpline and the website. Here at the board, we have a new claim system that's coming soon, the Business Information System. And basically, it's going to help speed up, for employers, it's good because it's going to help speed up the claim process. More access to real-time claims, online self-service. But again, the main takeaway from this is that your claims will happen more quickly. be handled more quickly, and your employees will get back to work more quickly. Be sure to follow the board at the various sites that we are on, and you can always contact my office at this number, 518-486-3331 is my desk. My email is my name, neil.gilberg@wcb.ny.gov. So please, if you have questions, it's always better to reach out to us and ask, and we'll give you the answer, and you'll have a good foundation for your business.